Good afternoon, everyone, and I'm all welcome to today's session. We're going to go through navigating AFCA's complaints and just looking at the legal and compliance insight for the underwriting industry, for your industry. We're delighted that you could join us, whether you're joining us live or watching the recording afterwards. Also wanted to thank greatly the UAC team for the opportunity to present this topic to you and for the team facilitating the session. The goal of the webinar is to give you knowledge, confidence, and practical tools you will need to navigate the AFCA process smoothly and compliantly. We'll be covering not only the regulatory expectations, but also the practical steps brokers can take to reduce the complaint lifecycle, avoid escalation, and achieve better outcomes for both clients and firms. By the end of this session, you should walk away with a clearer understanding of how AFCA works, what triggers a complaint, how to respond strategically, and it's about essentially empowering you to manage complaints proactively, reducing your risk exposure and maintaining strong client relationships. So navigating the AFCA complaints. So essentially, I am Mariana Svetanoska from Corporate Overhaul. I'm the CEO, founder, and principal of Corporate Overhaul Legal Services. We also have another firm called Corporate Overhaul, Pty Ltd. And what we do is we provide a combined service offering that we provide basically not just the legal advice, but also the compliance and risk management and practical advice you would need when implementing your any compliance obligations. But we'll go more into detail a bit later about our services. Joining with me are my two exceptional contributors, Fernand Sadak and Colin Talini. And Fernand has had extensive experience in complaint response frameworks that brings invaluable practical insight, and we've dealt with quite a number of AFCA complaints on behalf of clients. And then Colin Talini, who will help us bridge the legal concepts for the real world, with having experience with all the AFSL compliance, preparing AFSL compliance framework, risk management, etc. So with that information, let's dive straight in, starting with a look at the evolving AFCA landscape and what recent determinations mean for underwriting operations. Now, I will allow a Q&A session at the end of this presentation, but if anyone's got any questions, you can put them in the chat, and then we can go through the questions that you've put through a bit later at the end and answer any questions you have. So the agenda is understanding AFCA's role in jurisdiction, identifying what constitutes a complaint. And I know that, a lot of people think, oh, that's quite straightforward and basic, but there is quite a lot of, considerations in the way you need to approach it that will help you. And the importance of early engagement. And then we'll step through the AFCA complaint process stage by stage. So you know exactly what happens from the moment a complaint is lodged through to resolution or determination. From there, we'll explore best practice approaches on how to respond to AFCA complaints, including timing, documentation, negotiation opportunities, and we'll also, talk about common pitfalls where, licensed entities have found themselves in a little bit of trouble. We'll also give you some insights from AFCA public determinations. We haven't disclosed the actual entity that the determination was under, but we've given the case number so people can follow the link and read more about it if they're interested. But it's more like of a summary of, to talk you through of, when things have gone well on the way a complaint has been handled by a licensee, or where things have gone bad and the way, all those sort of, problems or issues that have arisen, or the way the complaint was handled that was inappropriate, that AFCA found, adversely against the licensee. Apologies. Then AFCA's mandate. So under Australian law, AFCA is mandated as the external dispute resolution body for AFSL holders and ACL holders. ACL holders, that's people that provide credit credit products that won't be relevant for today's purposes. They're there to resolve disputes between consumer, small businesses and financial firms. So insurers, brokers, any representatives of a licensee are what is deemed as the financial firms. AFCA operates as an alternative to a court, and also it's not a regulator. What that differentiates is that basically AFCA decides matters based on fairness in all the circumstances. They don't always necessarily follow the law. So, and I'll go into a bit more detail, in a few slides. And the other thing is determinations are binding on financial firms if accepted by the customer, and you actually don't really have a lot of room to fight a determination even if you don't agree with it, unless you can prove that AFCA made an administrative error, but not the actual outcome or decision that they made. And I'll give you a bit more details as we go along. The type of complaints within AFCA's jurisdiction the type of complaints is basically for general insurance is not limited to just whether claims should have been paid or whether policies should have been provided. In practice, AFCA regularly considers complaints about claims handling, delays, renewals and non-renewals, changes to terms, deductibles, or pricing, and critically how those decisions were communicated. Like AFCA will never make a call on how you price the product, but they'll look at the documentation you have in place to, and how you sort of, formed a view of, how you're going to handle a particular policy and increases, etc. So therefore, importantly, you have to remember that AFCA also looks beyond outcomes to conduct and service issues. They'll look at poor communication, misleading expectations, failure to follow up, or inadequate handling of customer concerns can fall within their jurisdiction, even where the insurance decision itself was correct. AFCA also assess complaints across the entire distribution chain. So customer doesn't need to correctly identify whether the issue sits with a broker, insurer, underwriting agency. If the complaint relates to the provision of a financial service, AFCA will assess the conduct of all relevant parties involved in servicing these clients. So the key takeaway to remember when it comes to AFCA is AFCA's jurisdiction is a lot more broader than many firms expect, and complaints often arise from process and communication failures rather than technical insurance errors. The monetary limits and exclusions relevant to general insurance is AFCA can consider general insurance disputes up to 1.263 million. Compensation that can be provided by AFCA is capped at 631,500 per claim. This excludes any interest that AFCA determines should be paid or any professional costs. There is a limit of 6,300 for any indirect financial loss and non-financial loss. So indirect financial loss is consequential loss, so that there's a limitation of 6,300 for that. Or a customer didn't suffer financial loss, but there was something that was not adequate from a customer perspective. And then some disputes may be partially within jurisdiction, but the thing is, but they'll still sort of look at the whole conduct. So the exceptions when it comes to AFCA is AFCA will not make any decisions on pricing, and they're not like an underwriting regulator. So they won't assess whether premiums were commercially fair or rewrite policy limits, but they will look at how the underwriting occurred, what the pricing decisions, whether the pricing decisions were appropriately explained to the customer, and they will still be assessed as a fairness or service issue. So the key point is that monetary limits constraint remedies, not scrutiny by AFCA when it comes to a complaint. So the implications for AFSL holders, authorised reps and distribution chains. AFSL holders retain the ultimate accountability for complaints and AFCA outcomes. So ASIC's framework expects financial firms to have an effective dispute resolution system comprised of IDR procedures and AFCA membership as required. And then ASIC also emphasises the broader AFS licence obligations around supervision and compliance, including ensuring representatives comply with financial laws. For authorised representatives, the operational implication is that a complaint about AR's conduct does not stay with the AR authorised rep. It actually will go to the licensee to handle. And so this is why it's important for the licensee to ensure that it's got appropriate framework. So there was recent, which I'll talk about a bit later, in 2021, legal changes where ASIC issued an instrument advising AFCA that they have to update the rules to make sure that it's very clear that the AFS licensee is responsible for the conduct of its representatives, whether or not even the conduct was within authority. That is in order for it to align with Section 917B of the Corporations Act, where under the Corporations Act, it says that an AFS licensee is responsible for the conduct of its representatives, whether or not the conduct was within authority. So if your authorised representative authority is active, and even if that representative acts inappropriately and outside of the power that you gave them, you as the licensee will continue to be liable for their conduct under an AFCA dispute process. And then it's a commercial matter between you and what action you're going to take on the authorised against the authorised representative based on your, behind the scenes agreement on when you've appointed them. So the instrument that ASIC issued is called the ASIC Corporations AFCA Scheme Regulatory Requirement Instrument 2021, which was directed for AFCA to amend the rules to now clearly extend AFCA jurisdiction to representatives, regardless of whether the conduct was within or outside of the authority that they were giving and that they acted inappropriately. So I need to stress that you should have a very stringent process in place from a compliance perspective, and even as a AFSL representative, if any of your representatives receive any complaints, that they get escalated to you, and then you proactively manage those, because whatever a representative does, you'll be ultimately liable and obligated to pay the customer if AFCA finds in favour of a customer and they're awarding you compensation. When it comes to handling the complaints, you need to also make sure within your process you have clear role allocation, like who decided, who communicated, who confirmed the understanding with the client. You also need evidence controls, whether you have to have appropriate file notes, system records, renewal and underwriting material, and and who has the communications. Then you need to have the narrative discipline, and this is what I mean by having oversight over your representatives is when it involves multi-respondent matters, so a few parties were involved in servicing a customer, you need to make sure that one person does the communication with AFCA, collates all the information, so then you have consistent timelines and explanations, because you don't want two different parties responding to an AFCA complaint and you give different information, because then it goes, it works against you from a credibility perspective. And then AFCA then can treat it as if there's an internal governance issue as well. So the takeaway is very simple. Delegation changes, who does the work, who carries accountability, what reporting do you have from them, and compliance arrangements. So if you take the approach of early coordination, single coherent chronology, and documentary support that demonstrates what occurred with the customer, this will go a long way in getting determinations in your favour. So how do we identify what constitutes a complaint and the importance of early engagement? So, complaint can be verbal or written, so you have to remember that. And any expression of dissatisfaction can be a complaint. So it's, defined within the AFCA regulatory guides. Expression of dissatisfaction made to about an organisation related to its product, services, staff, or the handling of a complaint, where a response or resolution explicitly or implicitly expected or legally required. So it doesn't need to have formal language to say I'm lodging a complaint. It could be I'm unhappy, I'm dissatisfied, or, thing. And then, complaints can arise before AFCA is even mentioned. And on how you handle complaints earlier affects the outcome you have through the AFCA process. Also, for those people that participate in social media, bear in mind that if you're doing any posts or doing anything, there might be customers, there might be lodging complaints actually through social media. So even if somebody's dissatisfied or make negative comments, it's important that you actually monitor the comments made on your social media pages, whether it's LinkedIn, Facebook, Instagram, etc. You need to proactively manage those comments, and then if anybody has displays some dissatisfaction with your services or your organization or your staff, you basically should message them, please email us at, and give them an email address that they can send you, and don't engage with them publicly on social media on resolving the complaint, but you should be able to, proactively respond to them and encourage them to reach out to you and file the complaint, through your internal complaints process. But that will go a long way, because if somebody says, I made a complaint and you didn't respond, you'll be able to say, we did respond to your social media message, but we will not, engage, through this form of communication. We want to do it offline due to privacy, and have them, interact with you. So even if you're responding and they haven't, I will do a follow-up. If you know who they are and you can identify them, I'll send them an email and, even try to call. And then if they, don't respond, then as long as you've recorded those, you could say that you proactively tried to, engage with the customer and get more information about what this dissatisfaction was about. And I just went through, I realized this slide to talk about the, the definition of complaint, etc. And I'll go to the next slide. So learning when dissatisfaction must trigger complaint handling. So the trigger is expectation of action, not the word complaint. Escalation point is earlier than many firms assume. Informal issues can become complaints mid-conversation. So delay in recognition can affect your fairness and credibility with AFCA. And then early classification shapes AFCA's, later assessment on how you're handling it. So you just have to be very cautious in how you're dealing with routine client inquiries. And then that could be a routine client inquiries that might become a dissatisfaction. So early engagement is very important. So just to give you sort of, an example, just say a customer, calls and basically, says that, they're talking and say, I'm not happy about this. I will then say, well, would you like to lodge a complaint? I can send you an email about it. And then even after the conversation, I will encourage and send them an email saying, look, if there's anything you're dissatisfied about, please, let us know and reach out on this email to, if you would like to lodge a complaint, etc. Just to sort of encourage and show that you were across, you were across with the client's needs, etc. So recognizing the benefits of early contact and early offer strategies is very, very important, because you can actually de-escalate and resolve issues before AFCA becomes involved. Because once AFCA becomes involved, one thing everybody needs to be aware of is that it doesn't cost the customer anything to lodge a customer complaint. And then they can go through the whole process, and by the end of it, with the way AFCA's pricing works, you could be looking at close to $10,000 paying just in AFCA fees, as well as the time and effort it will take internally for your people to actually manage the complaint, respond properly, make sure you satisfy all the responses that AFCA requires. So early capturing of the complaints is very crucial. Because it allows you to resolve it. So the key should be customer management, resolve the complaint as quickly as possible. That will make things a lot easier and cheaper for you in the long run, instead of running full-blown AFCA cases that, could be 10,000 of AFCA fees plus compensation, could cost quite a lot of money for organizations, and it could be, financially, very stressful. So, and also early involvement allows you to clarify misunderstandings before, customers have, hardened positions on, that they will write about something. It's easier to, get them at the beginning to explain and get them to understand if it's something you need to explain to them. So, and then AFCA will look at that very favorably, because early engagement will demonstrate that you are acting reasonably and in good faith. And then also just, human mindset, when somebody probably needs to be heard and informed early, and then there'll be less, adversarial with going through the process. If you're able to, reduce it, and again, improves your credibility if the matter proceeds to AFCA, but also helps you reduce financial, reputational, and systemic risks. So understanding the role of IDR, internal dispute resolution, before AFCA lodgement. So ASIC has a regulatory guide 271 that requires all financial firms, including AFSL holders and ACL holders, to have an internal dispute resolution in place. Make sure that your policy and internal dispute resolution process captures any vendors that undertake any license activities on your behalf, because something that could be done at their end could be a dissatisfaction cause to their customer, and you need to have that process working properly within your organization, have appropriate oversight. And as a licensee, I would prudently require all my representatives to escalate to me any internal complaints they receive. I would want to know how they're going to handle them, so you can have oversight, and whether you want to get involved in resolving it. Also, when anything goes and gets escalated to AFCA as well. So before a complaint can be lodged with AFCA, the customer has to give the financial firm an opportunity to resolve the issue through IDR. AFCA treats this step seriously, so you do have 30 days to resolve it. If it goes to AFCA, if that customer never came back to, never lodged an internal complaint with you, even if they lodge an internal complaint with you and they're not happy with the outcome, they've gone to AFCA, you still have an opportunity within that 30-day window period of the date they lodged the AFCA complaint to try still resolve it, without it then continue to escalate through the internal AFCA process. The purpose of the IDR is designed to do three things. Allows you to fix your problems early before the positions harden and costs escalate. It gives customers a clear explanation of the firm's position, which can a lot of the time resolve any misunderstanding. And then it creates a record that ACTA will later rely on if the matter proceeds and how you handled it. So they'll look at your IDR process very carefully. And the things that they'll look at when AFCA does a routine review of a complaint is how quickly you acknowledged the complaint when it first came to you, whether the response addressed the substance of the concern for the customer, the clarity of your response and the tone of explanation, and whether the customer was informed of their escalation right. So even if you feel that you've resolved something internally, you basically just get the customer to confirm is this satisfactory to you. If you're unhappy, you have the ability to go to AFCA for IDR. So you can actually stress that to the customer. During the process, even when you feel like you've resolved the complaint. And a lot of times, if people are satisfied, they won't take it further, but you would have done your job in disclosing that they still can take their complaint through the AFCA process. You can provide several remedies, waive-offs and fees and charges, apology or appropriate or partial remedies, or offer, a practical solution on how to do it. The other thing is the reason why you need to also, have proper record keeping of all complaints related to you as a licensee. It's because you actually also have to do IDR reporting to ASIC as well, which is every 6 months, about, internal complaints received, etc. So treat customer communication from a complaint or dispute perspective as an active dispute resolution opportunity, not a compliance in a tick of the box, right? If you handle it well, you reduce any issues with AFCA. And if you handle it poorly, it amplifies risks and frames the dispute unfavorably from the outset for the firm. Now I'm going to go through the step-by-step of the AFCA process. You've got lodgement and registration, referral back to the financial firm, case management, preliminary review recommendations, adjudication determination, and then we'll talk about at the end practical AFCA expectations. So from the lodgement and the registration stage, a complaint is lodged by a customer with AFCA. It could be directly to AFCA, or they could have come back to you initially, but they weren't happy with your response, and then they've gone to AFCA. So initially at the early stage, it's important to check whether a complaint lodged with AFCA is within AFCA's jurisdiction, right? Because I've seen quite a lot of times when, and this is for other holders, but I'll give you, credit license holders, but to give you an example, is where, you might have like somebody that does like debt collection, use that as an example, and, they might be collecting on, a debt of outstanding, I don't know, they've got those, I forgot the name, but they do the food delivery, right? And they tried to cancel the food delivery, didn't happen, they were charged, and clients will go and lodge a complaint with AFCA, right? Now, those complaints, AFCA won't be proactive in looking as to whether that's within their jurisdiction or not. So you've got to look at it, is the complaint within AFCA's jurisdiction? If not, get onto it straight away, because you'd want to be able to ask for a jurisdictional review at the early stages, where AFCA will go, thank you for lodging the complaint, but this is not within our jurisdiction. So that example I gave about, debt collection company and, somebody lodging a complaint because their, food meal delivery service wasn't cancelled by the organisation timely, and they're still being charged and chased for payment. AFCA will actually have to remove themselves from their complaint, because, anything to do that's not a, financial service or credit service doesn't fall within their range. So just double check that to just make sure, because there's another way to get out of the AFCA process if it's not within their jurisdiction, but you've got to look at the rules closely. Once a complaint is registered, right, then you'll be notified, and the matter will formally enter the AFCA framework. From that point, all communications and timeframes are governed by the AFCA rules, and internal handling should shift from compliant resolution mode to AFCA response mode. As I said earlier, AFCA will give you the opportunity to resolve a complaint, yourself first, and then after 30 days, it will continue through the process. And then as soon as a complaint is registered, you have to keep in mind that AFCA expects you to engage constructively and promptly to try and, resolve the complaint. So, AFCA, so the referral back to the financial firm, this is when they'll give you the 30 days to resolve it. And then if you don't, then it will go forward. So it gives you an opportunity to make sure that where there's multiple respondents, gather your information and try to resolve it with the customer for it not to go further, and then eliminate the cost that comes with going through AFCA. Which that would be my recommendation on how you handle this. So the complaint, so we're going to go to, case management. AFCA, so once the 30 days have passed, the complaint is not adequately resolved to the customer satisfaction, then it will move to case management. AFCA will allocate a caseworker, and then this is when all the information requests will be issued, and they'll ask for evidence and submissions. And they'll give you like timelines when you need to respond and all of that. So this is very crucial for you to manage this stage, because this is where your responses must become structured, evidence-driven, and fairness-focused. And AFCA can expect you to produce quite a lot of records, including your system notes, policies, procedures, etc. You are obligated to provide the information requested by AFCA, and you can't withhold anything just because you might, claim it's, confidential or it's got IP. If it's confidential, it has IP information, or affects another, it might be a complaint that might affect, personal information of other parties not involved in the case. You can provide that information to AFCA, but you've got to stress when providing that information that information is provided on a confidentiality basis, that it can't be shared with any other parties, only for AFCA's assessment, and you've got to explain why it can't be shared with anybody else. Otherwise, in the actually AFCA portal, everything you provide to them, the actual other customer, the complainant can actually see, unless you specifically advise AFCA that this cannot be seen by all parties, it's only for AFCA's eyes only. So be mindful that you're aware of that. And then for that kind of information, I would email AFCA and send it to them via email rather than upload the portal. So the complainant can't see if it's information that's, got, intellectual property confidentiality or privacy concerns. Communicate that to AFCA beforehand so they don't share any of that information with the complainant, but AFCA will review the information you give to them for their purposes of assessment. So as I said, when multiple parties are engaged, it's preferable on how you manage this, that you coordinate and provide joint submission of response rather than separate submissions that can contradict your positions. Because if there is a weakness in one party's response, then it will become everybody's problem that's involved in a complaint. So preliminary review recommendations. So at this stage, AFCA will provide a non-binding assessment, and they'll focus on fairness and evidence, and it gives you an opportunity to respond or settle. And a lot of the times, the preliminary review recommendation can signal a final outcome. If you ignore it, it carries a lot of risks, right? I have been involved in AFCA complaints for some clients where the preliminary review recommendation was actually wrong in the way AFCA applied and ignored a lot of issues. We pointed all of this out, and then AFCA still followed what we felt was incorrect view in making a determination. It didn't sway them. So just be very, very careful. So even if you have an opportunity to settle at this stage, and just to close the complaint, sometimes going all the way to the end is not worth the fight financially for you guys as the financial responding firm. But if there's anything fundamentally wrong in AFCA relied on inaccurate data, etc., point that out, because it's an opportunity to improve things and get AFCA to reconsider what they have wrongly used, like wrong data or wrong assessment information. So then the final process is like AFCA complaint process. So that's when AFCA makes a final decision. Now, unfortunately, when a final decision is made, it's binding on the firm, and no firm has any room to dispute any binding. You can't even go to court to take AFCA to court against any wrongdoing, unless you have, had, evidence of administrative issues undertaken by AFCA. So I'm just going to give you an example of a live case that this occurred a few years ago. I wasn't involved in it, but you can read about it. So there was a financial firm where they had appointed an authorised representative to act on their behalf. They cancelled the authorisation, and that authorised representative continued to take, so it was a managed fund, continued to take investors' money, representing their authorised representatives when they weren't. And then they got themselves into trouble and went into liquidation. Customers, when they were losing their money, started to basically, complain to AFCA and say, look, we've lost the money, this is what happened. And then because the company, the authorised representative company, went into liquidation, AFCA just encouraged the clients, the customers, to actually complain directly to the licensee. But the licensee had no idea that that this company continued to misrepresent that they're authorised when they weren't. And there was like about, 20 clients in total that made complaints. And then, the money that they were claiming were losses. It was like a number of millions of dollars. And AFCA actually found against the licensed firm and said, oh, you have to pay all this compensation. And the argument was, well, why am I responsible to pay compensation for a firm that acted unauthorized, because they weren't even authorized under my license? Actually cancelled that in October last year as an example, and they took the customer's money after that, right? And the thing is, then AFCA still found for them, so they had no choice but to take it to court. And then the court was able to overturn that determination because of an administrative error by AFCA, because they were acting outside of the authority and they were no longer licensed, right? What I'm just saying is, but that firm then had to go through the headache of having these determinations, trying to find avenues to take the matter to AFCA, find avenues to take AFCA to court just to have that overturned. Otherwise, they would have been liable for millions of dollars of, decisions made by AFCA for a party that they weren't even working with closely. So that's why it's very, very important to have strong record keeping. And even if you have somebody that's an authorized representative of yours, but they're no longer an authorised representative, lodge that, the ceasing of being an authorised representative of yours as soon as possible within the ASIC site. Don't have it, because even if they, just say hypothetically, they stopped, being an authorised rep on the 31st of January, and you haven't lodged that yet, if they undertake any conduct between then and the 19th today, you could still be liable because you didn't update ASIC's portal to say they no longer have authority, they can't operate under my license. So it's very, very important to have very stringent compliance and record keeping. So by the time the matter reaches this stage, the outcome is really a surprise. And most determinations reflect positions already signalled during case management and preliminary review. And then just to bear in mind is AFCA determinations are publicly available and de-identified, but they name financial firms. So then they, financial firms to then strive to make sure that they have, good complaint process in place. So they are not named in these determinations. Now, I know this is not related to the insurance industry, but I'll just talk about this, fairness and the way AFCA sort of applies their process. Is that, there was a particular case where, it was on a credit loan in this instance, but a customer complained about, their loan shouldn't have been given to them, and that loan was given to them in 2007. And the new National Consumer Credit Protection Act was implemented in 2009. And the thing is, and then they complain about some things under the new act, even though the loan was originated under the old act. And throughout the whole process, they had a case manager where they just would not listen to any of this, and actually found against the financial firm to say, oh yeah, if you apply today's rules, that loan should have never been given. And it was really absurd decision. So I'm just saying is, AFCA doesn't always get it right. They get things wrong. They don't, always apply the law fairly. So that's why engaging proactively, I can't stress enough on how it is important. And Fernanda will talk a bit later in the slides about, within your industry where people got it right or people got it wrong from AFCA determinations. And then there's been a number of firms where an AFCA determination has been made and they've determined that a certain amount of compensation has to be paid to the customer, and people haven't paid it. And as a result of that, ASIC has actually revoked their license and they can no longer operate in that capacity, and they've lost, their license, and they're banned from operating in the financial services industry. And then I've also seen scenarios where sometimes licensees, and there was a particular case where AFCA made a determination that a customer had to be paid, for example, $200,000 in compensation. The licensee, they didn't take it seriously. They got the final determination. They called up the client and they basically said to the client, oh, look, can we negotiate? We won't give you 200, we'll pay you, 50. Whatever they did. And the customer reported that straight to AFCA, and then they were struck off and they lost their business and the whole thing got unwound. So you cannot ignore any decisions that are requested by AFCA. Even if AFCA says you should do something practically, you need to do it. If they say that this is how much money needs to be paid, you have to pay it. There's no way around it to get out of that. Okay, so practical AFCA expectations. That timelines are enforced, and any delays from your end in responding, it damages your credibility. So if there is something that you can't make seriously, AFCA case managers can be understanding. And I would just, initially ask for an extension, but explain why I would be asking for an extension. But I wouldn't make this my practice where I'm constantly delaying responses or without providing any clear reasons why I need, a bit more time to respond on something. And sometimes you do, because they could provide 3 pages of information request, and you've got to gather all of that data and put it together. And obviously you, as a business owner, will have the BAU as well. And the thing is, so sometimes, information requests in the way people respond are a common failure point, because a lot of the times AFCA is not looking for advocacy or summaries. It's actually looking for the documents that you actually relied upon in, handling, customer inquiry, complaint, etc. or providing the service to a customer. Like, for example, I issued, the terms and conditions to Mr. Brown on this date, and, these are the terms and conditions that were sent to him by email to his nominated email address. Where your responses are incomplete, selective, or defensive, AFCA often fills the gaps itself. It's not normally in the firm's favour, and they'll just make assumptions. And then you've got to, argue back and forth to try and get them to see a different point of view. So it's best to be very clear in your responses to avoid any misunderstanding. And making sure that, you do have policies or procedures to address something. And sometimes you can actually explain something via system process. So even if it's not documented, like, for example, why did you ask for a customer's, passport? And you say, well, our system onboards a customer, we have to do, 100-point ID AML check, and they were asked to upload the passport for that reason. And you'll be able to show that it's part of your process, and it was explained to the customer that they need it. You don't necessarily at that point have to provide a procedure that says contact customer, ask them to email passport so we can do an AML check. Like, even if it's not prescribed, if your process has a process in place. So if your system and process, the way it's set up, has certain requirements in place, and customers are sort of, notified via terms and conditions, etc., that would be the evidence I would rely on. As I said, when there's multiple parties involved, please ensure that you coordinate and you have a joint response, not separate responses, because, AFCA will, if they identify any vulnerability, they'll actually stick to that and then try to basically then use it against, the firm. So getting these basic things right up front is crucial. Then it allows then AFCA to focus on the substantive matters rather than on fairness failures caused by your process. So best practices for responding to AFCA complaints. So basically, we're going to talk about how AFCA will assess the quality of a firm's response, not just the underlying decision. You'll see how AFCA applies fairness in practice, where they expects it in a persuasive response, and why evidence and communication are often decisive, even where the firm believes it is technically right. We'll also look at how responses should be managed, again, as I keep on stressing, with multi-party situations, so you don't unintentionally undermine your credibility through inconsistent explanations. So what does fairness in practice look like to AFCA? So AFCA decides on the fairness in all the circumstances, not legal correctness alone. So this is where I was stressing that prior example where it wasn't legally correct to rely on current legislation for a loan that was originated before a legislation was put in place, but AFCA determined that this was the fair way for them to look at it for the poor customer. So AFCA doesn't decide complaints in the same way you expect the court to. A court process would look at it legally, or as AFCA applies this fairness principle. So while legal rights, policy terms and underwriting decisions are relevant, AFCA is not required to stop at legal correctness, and they have to, which is embedded within their rules, and that's why they have this overarching power, is they can they have to decide complaints based on what they deem is fair in all the circumstances. Sorry, I'll just go back to, okay, so apologies, I clicked the button. What we consistently see in this scenario is whether, like, AFCA will look at, was the decision clearly and timely explained to a customer? Could the customer have reasonably understood what was happening, and whether there was evidence to support what the firm was communicating to the customer? This is why many of the AFCA findings turn on communication gaps, assumptions about client understanding, and lack of documentation rather than on policy interpretation or underwriting rationale. So being right is not enough. You just have to make sure that you're able to articulate and explain your process. And then you have to always look at complaints and put in the customer lens, look through the customer lens perspective. And then you do have customers, and I've seen them many times, where all of a sudden, they're educated enough to get a particular product and do it. When something doesn't go their way, then they say, oh, I didn't understand, you didn't explain it to me. And unfortunately, the way the law works from a financial services perspective, even credit perspective, credit license perspective, is that the obligation is on you guys as the financial firm to make sure that the customer understands, right? And the customer can play ignorant and you can't prove otherwise. There is no threshold to say you are sophisticated enough to know what you bought and why you bought it. You have to treat it as if you're, they don't know anything, and it's your job to educate them and explain why this product would be suitable for them. So had to respond to AFCA credibly and effectively. Start with customers' issues, not your defense, address fairness, apply the customer lens, then look at your legal or technical position, explain what was decided, why, when, and how, and support all your position with evidence of communication systems, etc., and coordinate responses and avoid finger pointing. So even if you want to point a finger at your authorised rep and then done the wrong thing, you don't want that to be aired during an AFCA process. That's something you should deal with separately with your authorised representative. Because if you're going through he said, she said, AFCA won't look at that. They'll just find, think that, you have no credibility and find it, or take an action against the financial firm. So the takeaway is make sure that your response to AFCA is strong. It's not defensive or legalistic, that you've structured it. It's transparent and evidence-based. And then it anticipates AFCA's fairness questions rather than reacting to them. If you handle this well, then the approach will materially improve your credibility with AFCA and will reduce the risk of them finding against you or being criticised. The other thing is what I wanted to talk about before, before we go into sort of practical examples of AFCA public determinations, is that when it comes to all AFCA decisions, you've got to make sure you have appropriate record keeping in from the beginning all the way to the end, to all the way being resolved, because there's been instances that I've seen where a customer will try to complain about the same thing 6 months later, and they'll try to find another issue and then get more compensation from it. What you need to do is, if you've gone through the process and you've settled anything from the beginning of the AFCA process and the end stage, I would enter into a settlement deed with the customer where they confirm, and I'll tell AFCA, look, we're happy to settle on this basis, and these are the terms, where a customer will sign a settlement deed to say, this resolve all my complaints with respect of this matter, there'll be no ability, and I'm satisfied, etc., etc. So if you enter into a basic settlement deed, a customer will not be able to raise a complaint about the same thing, because you can then use this agreed settlement deed and the previous AFCA complaint to shut down this new complaint. Because I've seen it time and time again, a customer gets what they want, then they try, and then in some customers, and this is just human nature, will think, oh great, I got some compensation, oh I'm also going to complain about this, but it was part of that one same sort of complaint overall. And they'll try to identify another issue that they're dissatisfied about and then try to lodge a second complaint. And this has happened where clients have listened to us, and when we ask them, do a settlement deed, get them to confirm that this resolves, then you're able to quickly shut down a second complaint, and AFCA will say, we cannot look at this again because you've already raised a complaint about the same thing. Or there's a settlement deed in place where you started the AFCA process, you didn't finish it because you agreed to settle with a financial firm, and you can't go back on it. And there'll be specific clauses within that settlement deed that basically stops them from raising this as an issue again. with you, and I would actually, in a settlement deed, include all the parties that were involved in the customer journey. So whether it's the authorized representative, licensee, underwriter, etc. I'll just include all the parties that the customer signs, because I have also seen where a customer will lodge a complaint against one party, and then they'll lodge a complaint about the same thing about the other party, and they say, but you're involved in that part of the process, and this is what you did wrong, so that it can double dip and try to get financial compensation from two different parties. We can prepare, basic template settlement deeds that you guys can use for your settlement. And then we can, if some things need to be customized, you can come to us and we can customize the wording. But having one, available for you guys to use would be very, very, useful. Now I'm going to go to the next slide, and I'm going to hand over to my colleague Fernand, where she'll talk about sort of the insights from AFCA public determinations, what this means for you, and then sort of looking at recent determinations, and then how AFCA has assessed those, and we'll show you what things were done well and what things were done not well. Fernand, I'll hand over to you.
Thanks, Mariana. So insights from AFCA public determinations. Can we just stay on the previous slide, please?
Sorry, the previous slide?
Yeah.
Okay, cool. Yeah.
Thank you. So AFCA's 2024-2025 annual review sets out the current complaint landscape and highlights where AFCA is seeing reoccurring risk across insurance distribution, particularly in areas such as communication, complaint handling, and claims processes. AFCA public determinations show how these broader terms are applied in real disputes involving brokers, underwriting agencies, insurers, issuers, and aggregator frameworks. While the annual review does not analyse determinations case by case, it clearly identifies the particulars that repeatedly lead to escalated complaints and adverse findings. Public determinations then bring those patterns to life by showing how AFCA assesses fairness, responsibility, and consumer understanding in practice. What we are focusing on this section is how AFCA's stated priorities translate into determination outcomes, so organisations across the insurance chain can better understand where the risk commonly arises, how seemingly small processes or communications issues lead to consumer favourable findings, and what AFCA reviews as reasonable professional conduct when things do go wrong. Next slide, please. So when we look across the recent AFCA public determinations involving brokers and other intermediaries, a clear pattern emerges. AFCA's reasoning is rarely about whether the insurance advice or outcome was technically correct. Instead, it focuses on how the customer experience was managed across the distribution chain and whether the customer reasonably understood what was happening at each point in time. The most common theme is communication, particularly around renewals, placement outcomes, and insurer decisions. AFCA regularly finds issues where information was provided, but not in a way that clearly explained the implications for the client, or not at a time when the client would reasonably act on it. Closely linked to that is client understanding versus assumption. AFCA tests what the client would reasonably have understood, not what the broker, underwriting agency, or insurer assumed that the client should have understood. Where understanding is assumed rather than confirmed, that creates risk. Documentation is another recurring theme. AFCA places significant weight on evidence. If conversations, explanations, or warnings are not documented, AFCA will often prefer the customer's version of events, even where the broker or firm believes they acted appropriately. Renewals and changes to cover are also a common pressure point. Non-renewals, changes in terms, insurer decisions, or limitations on cover are frequently at the centre of the determinations, where AFCA finds the processes were not handled clearly or proactively. Finally, AFCA looks at the process breakdowns across the distribution chain. That includes brokers, underwriting agencies, issuers, and aggregators. AFCA does not always assess conduct in silos, meaning it doesn't always look at each item, action, or issue separately or in isolation. It looks at who controlled the customer experience and whether issues were identified and corrected as they emerged. Next slide, please. So this September 2025 determination is a good illustration of how AFCA approaches broker conduct. The broker was found to have breached its professional duty of care, not because of policy wording, underwriting decisions, or market conditions, but because how the renewal process was managed and communicated. The issuer declined to renew, the insurer declined the renewal, but AFCA was not concerned whether the decision was reasonable or not. What mattered was the broker did not clearly explain to the client that the renewal had failed, that cover had ceased, and that what the consequences of that were. AFCA focused on what the client reasonably understood, not what the broker assumed had been communicated, and placed weight on the lack of evidence showing that the cover gap had not been properly explained. Even though no compensation was awarded, AFCA still made a formal breach finding that reinforcing the renewal and the non-renewal are high-risk moments, and for brokers, where clear explanation and documentation are critical. So what happened in this case is the broker actually offered to consider whatever claims were made during that uninsured period of time to assist the client, and the AFCA did determine that that was a reasonable outcome. So the customer wasn't awarded any financial compensation because there had not been any loss relating to this case, but the broker still was issued with a breach because their conduct was found not in favour in this case. Next slide, please.
Before you get on to the next slide, I wanted to just quickly add, the other thing is that AFCA also has the ability, if they find a number of complaints or even during one complaint, and AFCA somehow forms a view that you might have systemic issues within your process, they actually can escalate that to ASIC for investigation without informing you. Or AFCA could send you a letter and say, we believe that there is systemic issue, please provide information on the following. I have done a number of those for some of my clients where AFCA has formed a view, and then it was very important to go back, collate all the data, all the evidence to point out that it wasn't that there was no systemic issue, and that how that occurred, and you have to be able to explain it properly. So it's not just even if you find an unfavorable determination by AFCA, even if it doesn't cost you anything from paying a customer compensation, to get to the determination point, you'll pay close to $10,000 in AFCA fees and a bit more if AFCA deems it like a complex case. But in addition to that, they can actually issue a note to ASIC to investigate you because they believe that you have systemic issue within your organization. So keep that in mind, that you've got to treat AFCA as if you're being taken to court, and how you respond and do everything properly and methodically. Next slide.
So this determination from January 2025 is useful because it shows from the other slide of line that AFCA is drawing. So especially when contrasted with the previous determination that we just explored. So with this one, AFCA found a broker breach because the renewal, the previous one was where the broker was found in breach because the renewal had failed and that the client was not clearly informed of the outcome or its consequences. So AFCA focused on what the client reasonably understood, not what the broker believed had been communicated. So in contrast with this case, this is a January 2025 case, AFCA found in favour of the insurer, even though a material change was made at renewal, namely a significant increase in a peril-specific deductible. So the difference was not the size or the change or whether it was unpopular, but that the insurer had clearly documented and issued the renewal terms. The change was unambiguous and it was included in the policy documentation. It was provided within a timeframe that allowed the broker to review and to act on it. So AFCA accepted that the insurer met its obligations because the change was capable of being understood, even if it wasn't welcomed by the client. So together with these two cases, it shows that AFCA is not punishing difficult or renewal outcomes. It's assessing whether the renewal outcomes are clearly explained and evidenced and reasonably capable of being understood, regardless of whether responsibility sits with the broker or the issuer. We will also include the links to these determinations so that you can have a read of the full case description.
Yeah, so the link is actually at the bottom of the slide of that page. And so if you copy and paste that in the browser, when you do get the presentation, you'll be able to read into it yourself.
So next slide, please. So across AFCA determinations, the same structural issue appears repeatedly. AFCA regularly identifies over-reliance on information communication, particularly where emails are sent, but understanding is not confirmed. Simply providing policy documents is often not enough, and an explanation does matter. AFCA also focuses on whether firms took responsible steps to ensure that the client actually understood the position, especially where cover is complex or non-standard. The common theme is that consumer misunderstanding is often foreseeable and preventable. And where it's not addressed, AFCA is much more likely to find fairness issues.
Okay, and then I'll hand it over now to Colin just to talk about, our firm, and then we'll get on to the Q&A.
Beautiful. Good afternoon, everybody. Mariana, can you go to the next slide, please?
Oh, questions, yeah, sorry.
Although, no, there's a couple before that.
For some reason, it's not showing up on the page. I don't know why.
Well, I'll just like a brief summary about what we do. So like our vision at Corporate Overhaul is to be Australia's leading partner in legal, regulatory and compliance excellence. We want to empower businesses of all sizes to grow with confidence in a rapidly changing world. Who we are, so we are Australia-wide corporate and compliance consulting firm. We offer tailored legal, corporate risk and compliance consultancy services. We support the fluctuating demand of growing a running business, and we empower business owners and corporate operators to make informed decisions that align with their organisation. So pretty much where we aligned within the insurance industry, where insurers, underwriters and brokers require a financial service license or a representative authorization, we can help them apply for a financial service license with ASIC, and then provide the application preparation services like drafting your policies, preparing some procedures that you will need to, as well. And then we also provide the ongoing compliance stuff, because there are some ongoing obligations that you have as a representative or a financial service licensee, where you would need to update your policies regularly, ensuring that you're training your staff annually as well with compliance training. But we don't just fit into that kind of space either. We do have some other services. Was that slide not on there, Mariana?
It's not showing up for some reason. It's going straight to the question. So
we do provide like those specific legal regulatory services, but we also provide general legal services as well. So where we will provide contract reviewing, contract drafting, negotiating on behalf of your business as well in those contracts. We have a service where we provide an external general legal counsel as well, where we it's on an ad hoc basis, so it's really flexible in terms of where we can fit in with your business, and it really just depends on the structure and the workload of your internal legal team to how we can kind of fit in and help out with that. So we can the overflow of work, so there's a heavy workload on the internal team, we can take that work and do it ourselves, and then we can also just slip in there into the team as well, day to day, whatever you guys need. So we really have like tailored flexible services to be able to adapt to your business's needs, legally or on the compliance side as well. I think that is pretty much it. Thank you everybody for coming today. I think, are we doing Q&A, Right
Yes,
now, Marianne?
now we're going to do the Q&A. So if anyone's got any questions, I'll just quickly stop sharing the slides so I can see the pages for the Q&A. Does anyone have any?
Feel free to ask questions.
Yeah.
You've got
Yes.
one question in the Q&A section from Anthea. Do you want me to read it out to you?
Yes, please.
Yep. So she's saying, we often see inconsistencies with decisions made by AFCA on similar complaints, which makes it hard to judge how AFCA will view a complaint. Should we be seeing, sorry, let me just expand it. Should we be seeing more consistency with their outcomes?
To be quite honest, not really. And the reason why I say that is because you've got different case managers and you've got different level of understanding. So when I've dealt with AFCA, I've come across quite a large number of case managers who don't really understand the areas that they're reviewing in. That they're reviewing. They're not like legal or compliance professionals to even understand. So what you need to do is when you're dealing with it, you just got to even treat it as if AFCA doesn't know. Because what you do in the industry and what's well known in practice, it does not necessarily mean that AFCA has a clue about it. So you've got to treat it as if they don't know anything, and you've got to explain step-by-step process on what has occurred, why it occurred that way, what are your legal obligations, and you did it to comply with the law or whatever the reasoning was for it. And then you get more consistency. So the consistency is in how you approach the complaint and how you actually educate AFCA themselves with what's occurred, why it's occurring, how your industry operates, and all of that. So really the onus is on you. Unfortunately, they've got like certain rules, and then in their rules, they can't, document everything. So you've got to try to work within the rules, try to, close down a complaint if it's not within jurisdiction. I wouldn't entertain it because I've seen parties, not go through the jurisdiction route when it was clearly outside of AFCA's jurisdiction. They started with a complaint and then they said, like when they found out sort of halfway through, said, no, this is not even within jurisdiction. Then AFCA go, well, I'm concerned about your customer approach and I'm just going to still look at this. So it's very important that whoever handles your complaints internally, they're very well aware of basically the AFCA process. They're very familiar with the rules and how they handle that. And then you just got to treat it as if, doesn't matter, who's asking from AFCA, how senior or junior they are within AFCA, that they don't know anything. And it's up to you to educate them on how you operate, what your process is, why you did something, and how you try to resolve it with the customer.
I'll also just add to that, I've had, similar situations where I do feel your frustration because it's happened quite a few times where I would have a very similar complaint and would receive a response from an AFCA rep, and it's completely different from a previous complaint which basically had almost identical an identical scenario or situation. And I would commonly ask the reps why they are responding in one way for one complaint and not the same way in another complaint, which has very similar basic terms of what the issue of the complaint was. The feedback I get from them is they actually request to see the complaint outcome or the suggestions provided from that AFCA representative so that we can prove to them the reason why we've done things a certain way. And when they see that, one of their colleagues has responded a certain way or provided like a preliminary determination or their own views on a situation, they normally do consult with each other and then change the outcome that you're disputing. So it's very, very useful to keep records of the former outcomes and suggestions and feedback that you do receive from AFCA, because you can always go back and prove to them, well, this was the outcome on the previous matter, so it should there should be some form of uniformity. But going back to what Marianne is saying, yeah, it's very difficult, but there are ways that you can demonstrate that there are inconsistencies, and they will normally review and then come back to you with a more favourable response or outcome. So thanks for that question. Any other questions?
It says, in cases of potential fraud where the perpetrator of the fraud is using the complaints process to pressure the insurer into decision, what is the best way? to communicate the fraud concerns to AFCA without compromising what might be an ongoing fraud investigation. You can actually have a confidential conversation with AFCA about things. And if you believe that there is fraud, you can advise them, we believe there is fraud, and then AFCA will work with you in either delaying the process a bit further for you to finalise your internal fraud investigation, or go through the process and sort of, with that sort of sight in mind. So you won't be compromising on ongoing fraud investigation. I've had scenarios where a matter, there was fraud and had been reported to the police, and we actually let AFCA know that, look, this is, police matter has been reported, we believe there was fraud, it's being investigated, etc. And that could go a long way. So you can have those confidential informations with AFCA. It's like as if you're talking to like a regulator, where you can have confidential conversation about certain matters. We've had, people, like, for example, we've declined to provide a service because of AML concerns. They didn't satisfy their AML checks, and the customer complained, and AFCA wanted to look through that process. And then we went to, AFCA, we said, look, we can't give you more details, but there was AML concerns, and we cannot disclose any more information because of tipping off, right? And all of that. So then, AFCA sort of found a way to stop the complaint or sort of not proceed it, because they had trusted the information that, we gave them about, it being like, look, the service wasn't provided because of AML concerns. And you've got that legal obligations with tipping off. So so just got to look at it on a case by case scenario. And if there are serious concerns from that fraud, AML, or any other of those issues that arise, have a confidential a confidential conversation with AFCA, or get like a legal advisor to contact AFCA on your behalf and speak with them. So then you're not, breaching any other legal obligations you have, like tipping off, for example, under anti-money laundering laws. I just wanted to sort of stress with the services that we provide, and things that Colin explained, we do like fractional sort of internal legal counsel services. What that means is like people can engage with us where if you want sort of quick guidance, what should I do with this approach? You can give us a call, like as if you're talking to internal legal, and get that quick guidance. So you don't have to worry that, we don't operate like a traditional law firm where every time you come, you have to get a full-blown legal opinion. We can provide like practical, compliance guidance on matters and all that. And you can, call and seek guidance on a short notice. And then we've got different arrangements that we can discuss independently on how we can, provide that kind of a service. But you can have that sort of, interaction if you don't have your own internal legal and don't know how to approach some of these curly matters that come across.